arbitrators for the most part. Lawyers should be restricted only to making appearance on law or interpretation of law. The rest of the facts should always be presented by people who have the, the capacity, the acquaintance with the subject to be able to do it. Now, about framing the laws, one of the subjects he said we have to do is to frame the laws. Now, why reinvent the wheel? We already have so many models before us, like the Honorable Member again suggested, that we should really look at what has worked best. The tried and tested is always better than trying to do something and then undoing that. So see what has worked for so many years and what has been successful all these years, and then try and pick up from wherever and whatever suits us. It doesn't have to be all of one or the other system. It can be something from SIT and something else from England, which can happen. And the third thing, that I have, thanks to Mr. Kaviraj, he'd arranged some meetings for us to meet business groups in Germany. And one of the reasons why they said they really didn't want to have a lot to do with India was because they were afraid of the labor laws. And then, there was a promise made, of course, off the cuff by whoever was there, representing the government, that things will be done to improve the labor law. But we all know about the case of Suzuki, Maruti Suzuki, where the management and the labor went into such a long, drawn-out disputes. Now, these are all things that are going to leave a big shadow. And it's going to be very, very discouraging for people to really come here and set up shop. So therefore, I'm saying labor laws should be, employment disputes between management and the labor should be made arbitrable. Somebody said expand the scope of arbitrable issues. So one area where I think we really must leave courts out of it altogether and try and arbitrate disputes is between management and labor, because they form two sides of the same institution. And therefore, it should be more easy to arbitrate. There are 100 other points one can make. And to pick up on what Salami said, there's so many, things that has to be done. We all know what the problems are. If we can all collate and given our written, what are proposals, which all can be collected, I'm sure there are so many areas where we'll be, sort of saying the same things. So somebody should collate and, make a list of items and then perhaps present it to whoever is the authority.
We are doing this.
And just one last suggestion. Like you have arbitration tribunal, the National Consumer Court and everything else, a nodal agency is something for which the Ministry of Law and Company Affairs, which is, so keen to popularize, arbitration, should really pitch in and set up the infrastructure, because it requires a lot of technology. This is where the government, if it's seriously intentioned, should do something instead of leaving it to others to do it. And lawyers like Mr. Anand should Mr. Anand should participate in a big way to build up these institutions by giving lectures and training lawyers. Thank you.
Thank you very much, Lata ma'am. She reminded me correctly. We were invited by the CDU Economic Council. It's a Christian Democratic Party. That's a ruling party in Germany. They organize a meeting with the CMD and CEO of the German companies who are doing a business in India or planning to do a business in India. Their main concern was dispute resolution. So they say that it takes years to settle one case. So it's very frustrating for them. So our ADR is certainly a solution to these issues. Now, I will not take much time. Now, I will ask Suman who has summed up the issues raised by you, session given by you. And in the meantime, you can also ask a question if it's anybody's. Just let him start, and then he has summed up all the suggestions in one place.
Thanks, Mr. Kaviraj. May I take this chance to say only 5 M I have just correlated this. First is mindset, men, material, magnitude, and management. As encompasses all the discussion points here, most important of this is mindset. Everybody has said the mindset from the policymakers to lawyers to arbitrators to the society to the client should be changed. We all agree with this. We need to change. We need to change with the times. We need to change with the everything. Then come the men. the training of men, the men who are manning the agencies, the men who are helping the corporate, the people who are helping us, and we ourselves needs to be some kind of a change. Then is talked about the management. Mr. Anand talked about techniques, best practices, early hearing, and awareness. Ms. Lata Krishnamurthy has said this has to be a constant training of everybody, including lawyers and judges, and constant training. Yes, it should be. Then it's material. For this materialing, two things are essential. One is the nodal agency, and second is the infrastructure, which has been talked about by a variety of speakers. And lastly, the magnitude. We have the magnitude of population, magnitude of business opportunities, magnitude of the workforce, but we are lacking only the will. Let's all do it. And on behalf of INBA, I thank you all. We had a very nice discussion here, and thank you. Thank you all.
Yeah, anybody has a suggestion or addition of a point?
I rushed myself when I was speaking at that point in time due to Mr. Kaviraj being pushy, and I know we are.
Let me say one thing. Nobody likes me for my job.
Couple of things that I just wanted to point out in addition to what had already been said. Another very important thing was, as Lata ma'am pointed out, training of lawyers in itself. A very major issue which I think so I have heard a lot of times with institutional arbitration and ad hoc arbitration as well as costs. Now you have to understand costs are something which the legal counsel that you hire also plays a very, very important part in it. As institutions, yes, I can speak for SIAC ad valorem basis. That means the amount in dispute will determine what the total cost of the arbitration would be. Having said that, I'm not sure how many of the lawyers in India are aware of procedures like expedited procedure of SIAC, where any dispute which is less than $5 million can be arbitrated as per expedited procedure. Arbitration finishes in 6 months. And we've done that a lot of times in the past. Mr. Anand pointed out the use of technology and trial practices. Trial practices, to be very frank, since I said that I was practicing in Singapore before I joined SIAC and I came here, I only knew trials to have been done in one tranche. I never knew that there are dates in arbitration as well. I always knew that, okay, as many witnesses, 10 days, set aside for trial, done. We've done arbitrations. While I was with Clifford Chance, we've done arbitrations with Indian opposite parties being Indian and represented by Indian law firms, where they were sitting in India only and through video conference. So that means all these things exist. The question is of making it and putting them in use. And that's where I think so the change in mindset is at that level. Another suggestion that I wanted to make, how do we all speak about change in mindset. How do we achieve this change in mindset? We all attend loads and loads of conferences. We go there, we obviously we interact with a lot of leading individuals. But do we take away anything from these conferences? I think so, I consider myself lucky if I take a couple of valuable points from such conferences after attending the entire day. Such training workshops, if we do, why should people attend? That is where probably the role of the Bar Association and the Bar Council comes in, that the lawyers should be handed out points for attending such workshops, continuous training, something which is again practiced all over the world, but not yet in India. Things are changing, things are looking up, maybe this can be incorporated. Thank you.
Any other question?
One of the elements which is talked about is the training. I just wanted to announce here that LexisNexis, we have ADR, Alternative Dispute Resolution content around the world, and we are building a module in India as well. This product is called Practical Guidance, and it is more towards practicing lawyers as well as in-house counsel who want to quickly understand what the stuff is about alternative dispute resolution. So hopefully once this is ready, I think one of the challenges around training would get. Hi, this is Nirupam Shirva. So just wanted to let people know here.
Hi. Just to take on what Pranav said, and one of the gentlemen here, I think Mr. Bagga, spoke about branding India. I think it's very important how you're going to sell and position India. I think Singapore has done it extremely well. Now, one suggestion I have is, can we invite legal luminaries? Singapore has appointed people like Toby Landau and Michael Wong and all these very distinguished arbitrators. Whenever India sets up a world-class arbitration institution, let's make sure the chairperson is a renowned arbitrator. Take it from me, the global MNCs will only come when they have a faith in an institution which is led by a very strong leader. Let's start engaging them. And I think it has to be done very urgent basis, Ram, because we are running out. Let's have a very strong leader, someone like a Michael Wong or a Gary Bond, and then position India as at the very top. Because you have to really reach out to these guys. And then, as Pranav said, let's start leveraging SIAC or LCIA. We have a panel of arbitrators. Till the time India sets up or gets there, let's have a ready-made collection of arbitrators. So that's just one suggestion.
1 point, sir. 1 point, 1 point from here. And my little suggestion. Okay.
Oh my God, I just got another attention of people. I would just like to emphasize, I think, on the sectoral arbitration, especially on employment and employee relationship, though there are companies who are actually having arbitration clauses in employment agreement when it comes to enforcement of bond agreement. But when it comes to employment agreement, I understand that the arbitration clause is actually not valid, Yeah, because you have special codes like labor code, and they have a right under the labor code unless the employee is of a senior management, that is key employee, who is not governed under the employment laws. So I think if we can, have such amendment. Yeah, so that's what I said, and if we can bring that, I think that will be really very, it would be really good for the companies. Yeah.
Yes, Mr. Gupta, but please be brief.
Only 1 minute. My suggestion is that for institutional arbitration, the institutional should be registered at national level so that they have the same rules and regulation for all and the fees. And secondly, an arbitration clause be also drafted and incorporated at national level so that they have the same clause for all these. So the foreigner may also add and have a confidence over us.
Point taken, sir.
Else? Yeah.
Sorry, the way there are a number of manufacturers of consumer goods and builders. They are misusing this arbitration clause because this leads to, you can say, so as to avoid these consumers from consumer courts.
Yeah, Mr. Rajiv, let me give an example, practical, what you're talking about is, you're talking about a line written in an invoice that all disputes shall be subject matter of their association arbitration. And these are the people who are just work like a panchayat, as we have in old Delhi as well. So they are very skewed in one favor. That's the one you're talking about?
No. The way builders and manufacturers of consumer goods, they insert arbitration clause, whereas consumer, they have remedy from consumer court. And to avoid that, they insert arbitration clause.
So, any other question? Yeah, please go ahead.
I was just going to make one observation and probably a comment for all the GCs over here. Believe it or not, the Ministry of Commerce has a circular or a notice which says that it encourages referral of disputes to ICA, I think. That circular is still on its website. Despite that, whether you have a contract with NHAI, Power Grid, NTPC, whoever else, it's an ad hoc arbitration. In my limited experience, I have never seen ad hoc arbitration clause between two private parties, particularly in an international commercial context. I just wanted to ask the GCs over here, how many of you use ad hoc? How many of you have used LCIA India for the last?
As rightly pointed by our moderator, so is this question on a practical side we are not discussing. We are discussing on the broader. Yeah, well taken,
offline,
yeah.
offline, Anand, I'll
Yeah,
explain
yeah.
to you.
So,
Right. So this is a pure, again, a strategic observation. My concern is again, with putting all demands together, what should change. So there's a whole list, which should change, and we all want it together. So I think as an association, as a team of people who we are kind of very serious about making getting some changes done. Strategically, we have two options. One, ask for moon. Okay, ask for 20 things and maybe something will start rolling in, one option. Otherwise, really prioritize that, okay, let's have the basic one or two things and then they'll set the ball rolling.
Mr. KTS Tulsi, I'm sorry, but yeah. Mr. KTS Tulsi has arrived. Even though he is late, but we welcome him and we welcome Sri KTS Tulsi ji, who has been our supporter and he has been very prompt in accepting our invitation in the past, and we really sincerely thankful to him. Let me say a few words about what went into organizing these roundtable discussions. We received more than hundreds of pages of the suggestions from across the sector. We have involved the business community, we involved the other professions, we involved lawyers from the different backgrounds. So it's not the only lawyers we are talking about, because once we talk about the ecosystem, we talk about the entire nation, where we need to seek the suggestions from the business as well as the lawyers and the government representation as well. So we will present the paper to the government of India. Lot of hard work has gone into it while compiling or this simple 12 questions. It's not a one-day job. I will sincerely thank Mr. Ramaswamy, Saloni, Mr. Suman, but Ramaswamy has worked and I don't have a word to say.
But burn the midnight oil.
Oh, okay. And I am the most hated person because I know, I'm certainly sure about it. Nobody likes me in the conference because I keep maintaining a time and keep disturbing everybody. So I will ask Mr. Ramaswamy to give a vote of thanks. But before that, our chief guest, Mr. KTS Tulsi ji, to give us his valuable. Yep.
I'm sorry I'm late, but I was caught up in a matter and I'm coming straight from the court. As a result of that, I haven't even brought my note. I couldn't go home and pick that up. I was told that I'm very late. But I want to say that sometimes in 1975, I had approached Justice Dua for an arbitration. And in his opinion, he said that the arbitration in India is more arbitrary than any other process. So I entirely agree that if we have to gain eminence of the level of international arbitration that takes place in Geneva or Singapore, we have to make radical changes in the Arbitration Act. And major problem is that at every step there is interference by the court. arbitration is by itself not enforceable, the award is not enforceable, then you have to, but the courts can set aside the award. Either there can be an arbitral appellate tribunal and the jurisdiction of courts can be barred, but you can never bar the jurisdiction of the writ court. That is a constitutional remedy. So long as eventually after 2 years, 3 years, 4 years of arbitration, you have to go back to the court, then parties would think that why not begin with litigation only. But litigation is the only reason why arbitration thrives still in India is perhaps because litigation is never ending. It takes decades, not years. The problem with arbitration also is excessive reliance on the retired judges. And as a result of that, it's become extremely expensive. The fee structure is, there is no fee structure. They can charge whatever they like. And the retired judges can fix the fee at 1 lakh, 2 lakh, 3 lakh a day. And then they will define a day to mean 1 hour. So if it's 1 hour, 1 minute, it's 2 days of fee. And not many parties can afford that kind of fee. So arbitration is as expensive or even more expensive than civil litigation. So why would people like to resort to arbitration? We need a separate set of trained arbitrators, and and reduce our dependence on judges, because retired judges have a lot of experience, but they have not much of motivation. So I think that if we have to take arbitration in India, we have to borrow something from the Brazilian model and have an institute of world class which can possibly, at least for normal disputes which are not too complex, be able to render an award within about 6 months. And we should also be able to persuade the court to narrow down the scope for interference by the courts in India in arbitrations. Unless there is clear evidence of misconduct, why should anyone interfere? Because arbitration is also a settlement between the parties. And when there is no finality to that, people would be wary of adopting this remedy. Well, that's what I have to say. Thank you.
Thank you very much, K.T. Tulsiji, and for sharing his rich experience in the legal field. And I would request Mr. Ramaswamy to say a word of thanks and to appreciate the efforts done by the people to make it possible.
Honorable Chairman of today's meeting, Mr. K.T.S. Tulsi, Honorable Member of Parliament, Mr. Virendra Sharma ji, Praveen Anand ji, Lata ji, all my fellow colleagues out here and seniors, first of all, a big round of applause to all of you for having made it. It's a full house. It shows that the cause for which we embarked upon has given us the right momentum. The end is still far off, but at least the road that we have taken is the right road. So it's a big, big thumbs up for all of us that we are on the right footing to create a kind of a different environment. Having said that, a lot of effort, yes, but it's definitely not my own effort, it's a team effort. It couldn't have been possible but for the engagement of all of you out here. Last but not the least, I'll quote 2 things. In unanimity, whatever is the observations which came and with some more new ones which came, in practicality, we all understand that the system needs a bit of a overhaul, a new mindset, a cultural shift. I'm just drawing here 2 lines which I just wrote down, and it seems like a kind of a prophecy which is coming, and I'll read it out for all of you. In one of the questions which I had written finally, which got omitted, drawing from the Singapore model, the island nation has emerged as one of the key centers for arbitration in the East. Now I'm being I'll pause and I'll repeat it. In the East, due to A, sensible laws, B, high quality practitioners, C, a reputation as a corrupt, free and neutral venue, and lastly, an arbitration savvy judiciary. India is not lacking in anything else excepting possibly uprooting from the root the malice of corruption. Otherwise, as far as our own intellect, the West has borrowed from our own intellect. We are there everywhere. Having said that, still wearing the cap of a GC, let me share with you, which I think most of the GCs here will agree, is what I call the 5 essential elements of corporate compliance. Now, link it to whether it's arbitration or anything else. Set the tone at the top. For companies which say, right from the board of directors or others, here I would say the country, the prime minister, the agencies which will be involved, set the tone, set up mechanisms, set up an nodal institutional or whatever we may call it, a kind of a framework to work on it. Second, set up systems and procedures to back up that set the tone at the top. Here is where most of us spoke about how do we set it up. So do we have the policies, procedures, rules, in this case, a uniform kind of a rule in place which will set that motion. Third, training, constant training, a point which has come out in equal measure and uniformly from everybody. Fourth, is there a review mechanism in terms of auditing? So do we have a time period? It's not that once we fix a rule, it will go on till eternity. Times are changing. Maybe it will require 6 months, 1 year review. And as rightly said, it's a huge cake. Let's eat it at different levels. So first point, possibly my considered opinion, is the government should look at the concept of creating a nodal agency in whichever form. A present form already available, take it forward. Good suggestion. Link up. We are in a global world. I remember when I was in Honda, we used to call ourselves a global local company. In the sense, global vision in a local environment. The world is at our stage. Why don't we use the best practices available everywhere and dovetail it according to our cultural shift? And finally, what we call it, the PDCA, plan, do, check, action. We need to come back. It's a wheel which keeps on rotating. It will not stop. So that's my take. All these suggestions, we are going to put it together. I've already told Mr. Kaviraj that our souls are really going to, ache. But we are going to go to each and every decision maker within this country. And we assure you, maybe as an organization, a voluntary organization, we'll do something different. And maybe urge every one of you to really, put on their thinking caps and take it together. It's a wonderful nation that we have. We want to create a better tomorrow for our children and for the others. Thank you very much.
So now we have a tea and snacks available outside the venue. Can we have a photo? Yeah, photo. We can have a...
Don't thank the entire INBA staff who have practically burned the midnight oil in working on this. A huge round of applause to all of them, including the student community.